हेलो एवरीवन। आज के वीडियो में we will be discussing about a case law from Sale of Goods Act 1930. The name of that case law is Clark versus Army and Navy Cooperative Society Limited. This case comes under the point warranty of disclosing the dangerous nature of goods. The facts of this case are: a lady named Mrs. Clark went to this Army and Navy Cooperative Society Limited, wherein she purchased a tin of disinfectant powder. She purchased a tin of disinfectant powder. She used it, she opened the tin in a normal way, and the powder flew into her eyes and injured her eyes. And therefore, she has filed a suit against this Cooperative Society Limited, stating that they should have informed her about the way to open the tin of this disinfectant powder. The plaintiff, so when I say over here the plaintiff means Mrs. Clark. Plaintiff purchased a tin of disinfectant powder from the defendant. Defendant means the Army and Navy Cooperative Society Limited. So when a civil suit is being filed, under civil suit, the parties are called as plaintiff and defendant respectively. They are called as plaintiff and defendant respectively. So plaintiff is Mrs. Clark and defendant is the Cooperative Society Limited. The lid of the tin being defective, when the plaintiff tried to open it in a normal way, its contents flew towards her face and injured her eyes. The fact of the defect in the tins was known to the seller at the time of sale. It was held that the seller was guilty of negligence in not giving due warning to the buyer about the said defect and was therefore liable to compensate the buyer. Romer LJ observed, I think that apart from any question of warranty, there is a duty cast upon a vendor, that is a seller, who knows of the dangerous character of goods which he is supplying and also knows that the purchaser is not or may not be aware of the dangerous nature of the goods, to supply the goods without giving some warning to the purchaser of the danger. Iska matlab, seller, when he's selling the goods which are of a dangerous nature according to him, or certain special care is required to be taken while opening or while using those goods, it becomes his duty, it becomes his obligation to disclose the dangerous nature. It becomes his duty to disclose the dangerous nature of the goods. So in this case, the cooperative society failed to inform about the special care which was required while opening the tin of disinfectant powder, and therefore Mrs. Clark suffered injury to her eyes and she has filed a suit for recovering certain amount of compensation from the cooperative society. This is all about this case which comes under warranty of disclosing the dangerous nature of goods under the Sale of Goods Act 1930. Thank you.